they're going to take a hardware case or two or three at some point or other.
They
Am I
absolutely will. And
reading
even
this
Kavanaugh.
completely wrong? I mean, or
No,
should
no,
I be more hyperbolic?
the folks who think they don't want to take a case are inappropriately attributing some kind of hostility to the Second Amendment to the justices. We have at least four, more like five, and maybe even six justices that will rule in our favor on a hardware case.
Chuck, thank you very much for joining me again. It's been a kind of an interesting few days. Friday was interesting with the Supreme Court. I've seen a lot of people talking about the Supreme Court denying us and bagging us again. I don't think that's where it's at, but that's not in my wheelhouse. It's in yours. So I figured I would love to have you come on the show and clarify what's going on at the Supreme Court, and then we can talk about other cases as well. So so there's the question for you. What's going on at the Supreme Court?
Well, the short answer on the Duncan case is it's just been relisted. It was not accepted and it was not denied. So the court will have another. They probably haven't decided at their conference. On Thursday or Friday they'll have a conference. Then on Friday or Monday they'll issue orders saying, based on what happened in this conference, we either accept this case or deny review in this case, or whatever actions they're going to take. So they come out with an orders list either on Friday or Monday, typically Monday. So we were watching for it today, but something came out on Friday that said, here's some cases that we're taking action on, and Duncan was not listed, and neither was Gators Guns, which is another magazine case, or the Viramontes case, which is the semi-auto ban out of Cook County, Illinois. All three of those cases were scheduled to be heard, but no action was taken on any of them. So we'll get another notice about when they're going to have a conference on them again, and then they'll make a decision. And there's two cases that the Supreme Court has accepted: Hermani and Wolford. Hermani is drugs and guns, and whether or not someone who smokes marijuana can possess a firearm. And unfortunately, that's not a real fact-friendly case for us. It's a criminal case. The guy made some admissions. There are other marijuana cases that are also pending, asking the Supreme Court to hear them. And then the other one is Wolford. That's the vampire rule out of Hawaii, where the state law would require private property owners, which were open to the public, to post a sign that says guns are allowed, as opposed to the way it's done in every other state is if a private property owner doesn't want guns on the property, they can, it's not the government acting. The private property owner can say no guns allowed. So it's a matter of whether you say no guns allowed or guns allowed. If you try and get people to post a sign that says guns allowed, nobody's going to post it. So that was Hawaii and California's strategy. Luckily, we got the vampire rule in California struck down, but Hawaii's was upheld. So the Supreme Court's agreed to consider that. Now, the good thing about both of those cases is the Supreme Court's going to have to address the Bruin methodology. And this is where we keep getting taken advantage of by the Ninth Circuit and Second Circuit and other courts like that, where they are hostile to gun ownership, and the judges really are showing bias, and they twist the language of the Second Amendment. They twist the language of Bruin, I should say, so that, for example, in the Duncan case where they were dealing with magazines, the Ninth Circuit said magazines aren't even arms, so they're not covered by the language of the Second Amendment right to keep and bear arms. They're not an arm. Well, what are they? Oh, they're just an accessory. Well, wait a minute. I mean, so is a barrel. So is a trigger. And Judge Van Dyke did a great video on this, explaining you can't just say that you can ban a gun part, but the rest of the gun, you can make the gun useless. What are you going to? You can only have a one-shot Derringer. I mean, ultimately, it doesn't make sense. So the Supreme Court might just take the Duncan case. I've seen some other pundits saying this. Might just take the Duncan case and address that one issue. Remember, they don't have to address every issue that's raised in a case. They can pick and choose. And so they could say, well, we're going to just address whether or not magazines are arms, covered by the right to keep and bear arms. And that would be fine, because that's one half of the process. And we really need it clarified. What is an arm? It should be any bearable arm is an arm. And so,
Well, didn't they already decide that back in? I mean, that's
yes,
like
they said it.
back
They
in.
said it. They said it. But they didn't address like so. The courts have said that suppressors or stocks, bump stocks, and those aren't arms. These are all components, but that's not the question. They are ancillary rights that go along with the right to keep and bear. It's just like ammunition. They all go along with the right to keep and bear arms. Then the second test is the historical tradition test, whether there's historically some law that indicates that the founding fathers would have tolerated the modern day law. And that's
Is
another
that where the
area
vampire rule dies? Because it seems like it gets creamed at that step a lot, this whole vampire thing. Because the country's 250 years old, and for 250 years, you've been allowed to carry wherever you were legally allowed to carry it, unless like in a store or whatever, unless the store said no. Not the other way around.
Exactly. There's never been an incident where they've had to, there's any kind of a law that said you got to post a sign that says you can bring a gun here. There's been plenty of places where they've prohibited firearms. But back in
but the default has always been you can unless notified otherwise. Right?
Exactly. Yes.
Yeah.
That's always been the case. Now we're only looking at 1791, that era there. We're not looking at the Old West where, the firearms were checked at the sheriff's office as you rode into town. Those are a questionable constitutionality in light of modern day decisions. But go back to 1791. They might have prohibited guns in some places, but they sure didn't require the proprietor to post a sign that says, yeah, bring them on in. So, yeah, it's contrary to the historical tradition to require this.
So they have cases currently, which you mentioned. I'll be surprised if they don't take the Duncan case at some point or some similar case. It seems like they want it. Is what's holding this up? I guess I just should ask the open question. What is holding them up in taking them? I keep thinking maybe it's the fact that they're overwhelmed with all the Trump cases. Trump's getting sued here, Trump's getting sued there, and they keep having to fast track him to the Supreme Court. Is that a problem for us?
I think that's part of it. I think they're definitely flooded with work dealing with challenges to whatever Trump is doing, and everything he does gets challenged. But also, they have two Second Amendment cases on the docket on their that they will be hearing. That's pretty big. Even though they're not exactly what we want them to hear, which is an AR-15 case or a magazine case, hardware case, that would really finally answer the big question. Remember, there's three big questions: who can be banned, where can a gun be banned from, and what guns can be banned? Those are the three primary avenues for regulating firearms. And the Bloomberg folks just want to ban everything from everyone from every place that they can. You know what I mean? So they're pushing to ban as much as possible. We're fighting to save us all of it. So there will be a prohibited persons case in the Supreme Court this year. That's the marijuana case, and there will be a prohibited places case this year. That's the vampire rule case. So they've got 2 out of 3. Now we really need the hardware question answered too, and that's really the one that's getting the most attention and the most pushback from certain courts.
People seem to think I make a fortune on GunGuyTV. Well, I don't. Where I make a living is at Practical Defense Systems. It's the training company I own in San Diego. If you are looking toward security as a career, we're a great place to start. We're a state licensed vocational school. For that matter, if you want a concealed carry permit and you're in the San Diego County area, or you just want to take some great courses and training courses in our simulator, you can do any of that. We're in Mission Valley in beautiful, right next to Hotel Circle in San Diego. Check us out at Practical Defense Systems. You can go to the website, which is at pdsclasses.com, or look in the description of this video. You'll find a link. Every time the court doesn't take a case, well, that's probably an overstatement. I shouldn't say every time. A lot of the times that the court doesn't take a case, it gets all the way there, which is a Herculean task in the first place to get them to actually look at it and put it on in their conference and talk about it. It's expensive. It takes years. It finally gets there, and then they don't take it. And the immediate reaction is, the court hates us. The court hates our guts. It's never going to do anything. And it's all this negative hyperbolic stuff. I kind of want to bring it back to reality again. I don't see the current Supreme Court, personally, I don't see them hating on the Second Amendment. I don't see them hating on firearms rights. It seems to me they've made some great decisions with it.
Yes.
They're not necessarily grabbing the cases we want them to grab, but we want them to grab them. But I personally kind of feel like they're going to take, they got two. They're going to take a hardware case or two or three at some point or other. Am I reading this completely wrong? I mean, or should I be more hyperbolic?
The folks who think they don't want to take a case are inappropriately attributing some kind of hostility to the Second Amendment to the justices. We have at least 4, more like 5, and maybe even 6 justices that will rule in our favor on a hardware case, and on all these Second Amendment cases. So the court is not hostile. Maybe 3 of the justices are hostile, but the court is not. And Alito and Thomas are like gung-ho to take everything. So, and Kavanaugh has said they're going to take an AR-15 case either this session or the next. But they really need to take it this session because of all this big backlog of bad decisions that need to be swept clean. But no, the court is not. The Supreme Court is not hostile to the Second Amendment. They are very favorable because it goes back to the originalism. The court is moving towards originalism as a way towards interpreting constitutional law, and by that I mean they're looking at the historical traditions. They're saying, what did the founding fathers, what did the drafters of the Constitution mean when they said this? As opposed to the progressives who want a living Constitution where they can read all kinds of things into it to make it fit with their notions of what today's constitutional rights conception ought to be. And so the justices are like, hey, we may not agree with it, and you may not agree with it, but this is what the Constitution meant. It's just a piece of paper, has words on it. Those words had a meaning at the time. The meaning hasn't changed from what was in the minds of the founders when they wrote it.
I guess the question would be, so what should the response of the average gun owner be when obviously there's arguably a lot of frustration?
Oh, God, it's taking so long. Believe me, I know frustration.
You and I had a lot less gray hair when we started this, brother. And and now yours is white and mine's getting there. I mean, at some point or other, people just get dog tired. I take solace in, when I started this, we didn't have a Second Amendment to argue. There was no interpretation. We had Miller, which was ages old, that was constantly being misinterpreted about whether or not the Second Amendment was a collective or an individual right. Was it a right for the state to form militias, or was it an individual right? Heller clarified it's an individual right, and that changed the game. But before that, I was arguing due process and preemption and equal protection and all these other doctrines that the Second Amendment. I mean, the Second Amendment is the big friggin' hammer. Okay. And now, is it taking a while? Yes. But will we eventually get there? Yes. And has the game changed dramatically since 2008 when Heller came down, and now again in was it 8? And then I think it was 20. It was 2008, I think. But the point is that we used to have to deal with the whole means-in scrutiny crap,
right?
Intermediate scrutiny and balancing tests and all that other BS, and we just never could seem to get a victory anywhere until the game changed, and the game changed because of this Supreme Court, didn't it?
Yes, the game has changed. Now, lower courts don't like it, and that's not unusual either for the Supreme Court to make a decision. Look at after the schools integration, segregation was struck down. Southern states went nuts. They didn't follow that. They didn't agree with that. Lower courts always said that you could do whatever it is they wanted to do to be racially prejudiced. There's always been, throughout time, the Supreme Court comes down with these big rulings that change the game on everything, and the lower courts are resistant. So it's not unusual. It's just slow and frustrating because it takes so long.
I want my grandkids to have their rights, and I want my children and my grandchildren to have a country. And the truth is, we have a country because we have a First Amendment and a Second Amendment. And they've both been under fire for a long time. I mean, certain people are fighting in the First Amendment space, as are you, for that matter. But I mean, and people are fighting in the Second Amendment space. But those are the keys right there. If you don't have the ability to assemble, if you don't have the ability to express your point of view in the public square, which arguably is no longer a public square, it's social media or whatever, like this, if you don't have the ability to do those things, then you don't have a country, because what you have is a dictatorship. And if you don't have the Second Amendment so that the government is scared of you, because the truth is, the citizens should not be afraid of their government. The government needs to be afraid of the citizens, and then the government will behave. So we have to fight for these things, even if it's not for our own ability to go to the range this weekend and use a standard capacity magazine. We need to fight for them so that our children and grandchildren, grandchildren's grandchildren still have a country. They're not going to have one otherwise.
We're fighting for the soul of this country, and that goes far beyond the Second Amendment. That goes to all the whole fraud, waste, and abuse in the government being the solution instead. The government's not the solution. The government's the problem. Some people think the government can solve all the problems. They want to have a big government and take away individual motivation and the profit motive and all that other things that they want to strike down capitalism. So that's really a much bigger picture, obviously, than the Second Amendment. But the Second Amendment is probably the tip of the spear on that.
You may have noticed that my videos are no longer monetized on YouTube, at least not the new ones anyway. And that's because I'm kind of sick of YouTube, to be honest. So instead, I'm going to talk to you about one of the sponsors that's been with me since day one when I started this channel, and that's Second Call Defense. I've used them as Second Amendment self-defense coverage that entire time. I actually did have to call them once. They did a marvelous job, and I'm very pleased with them. I want to recommend them to you, Second Call Defense, if you're looking for coverage in case you ever have to defend yourself with a gun or a knife or anything else for that matter, and you want somebody to get you bailed out of jail if you get arrested and take care of your court cases in both civil court where you get sued and criminal court in case you're prosecuted. Second Call Defense is a great choice. Look for the link in the description, and if you would use that link, that would be great. That gives us credit where I can actually keep the lights on here at GunGuyTV, so that's always positive. Second Call Defense, check out the link in the description. Well, I think the big picture is important, though, and we don't talk about it enough. And the reason I say that is because we go back to the founders a lot. And we say, well, the founders said, and the founders, and we read the Federalist Papers and those kind of things. But I think what sometimes, perhaps, we don't think about enough is the founders had a long view. They took the long view on this. They had short-term things they needed to accomplish. They needed to take the Brits and throw them the hell out. They needed to get rid of the king. They needed to establish their own country. But they had a very long view as to how this country was going to exist for a long period of time. And it's been here 250 years because they took the long view. And most of the signers of the Declaration of Independence paid dearly for that.
Yeah.
Dearly. And I think we forget that. And so if I say this to myself to remind myself, but also you if you're watching Chuck and I talk about this, we have to adopt the long view. And here's where it fails, I think, Chuck, and help me out with this. Here's where it fails. If we take the long view and we realize it takes a heck of a long time for the Second Amendment Law Center, for CRPA and others to get these cases to boil up to the Supreme Court so that we can at least have a chance of them being heard, and then we're in the process of this. We're worried about it because we have slow Joe Biden in the Oval Office, and he's going after the Second Amendment. Trump shows up and says, "I'm for the Second Amendment." And we all go, "Oh, good." Whew. And we stop supporting, and we stop writing letters or whatever, and we stop calling the congressman or whatever, even though we feel like it won't do any good, and we stop donating to help CRPA, Second Amendment Law Center at all, do this kind of work. I mean, I don't know if that's happening, but I know human nature well enough to suspect
it happens to some degree. I mean, people aren't donating like they were because they think the problem's solved, but it's not. I mean, you have to lock it in. Just because the ball started rolling, and I just got a notice that the Second Amendment section from the Trump administration is now live online, so you can actually see what their agenda is. This is the kind of thing that Trump is doing. Trump administration, I should say, is doing. And Harmeet Dillon, who I got to give,
I love her. She's great.
We need to make a brass statue of her, man. But
to clone her and have her just put her clones in all these offices.
But see, Trump is aware of this. That's why I think. Okay, we're going to digress a little here.
I've been doing it. So you wax all you want.
when he took 4 years off, I think that really gave him some chance to reflect and think about how fast he needed to do things in his second term after 4 years off. So he looked at all the problems they were having, and he was on the ground, loaded for bear, ready to launch. He had everything, ready to go, and he knew what he wanted to do. And he knew that there's only so much time that a president has, or anybody has, to get certain things done. And so he's just been pushing the envelope to get everything done. Because
I think he said as much.
The plan of the Democrats, of the progressives, has always been flood the market, flood the country with people who want to vote for you because you give them free things. And so, that's their whole plan. Give illegal immigrants the vote. There never would have been a Republican Party. And so that's the fight that's going on between big government and perennial Democratic rule, progressive rule, and small government and individualism in the conservative party. So, I mean, I don't think it gets any more significant than that. And again, Second Amendment's the tip of the spear. But getting back to that, I mean, Trump has put all his staff's energies into that.
We are winning in courts. We are winning in legislatures. We have the support of the federal government. Harmeet Dillon's amazing. They're doing a lot of stuff that we could only dream of and just didn't even seem like it was possible before. And yet some of us are resting on our laurels, and we're not finishing the fight. And that's the frustrating
the courts
part.
they're not going to, just because the federal government's on your side doesn't mean the courts are going to hand it to them or you because they're on the same side. And by the way, the DOJ, for the first time ever, filed an amicus brief on behalf of the Second Amendment in the Walford case in the Supreme Court. They're getting involved. They got involved in the LA County Sheriff CCW foot dragging case. And it looks like they're going to come into the Rhodey case, which is now being heard en banc in the Ninth Circuit. And Harmeet Dillon came out and argued in the Seventh Circuit against that state's semi-auto law. She came out and actually took some time at oral argument to make the federal government's case clear, in addition to their brief. So they are engaged, and that will, that does increase your chances of getting a case heard by the Supreme Court when the Solicitor General's office says you should take this case and they want to participate. So we just got to lock it in, folks. Keep. It's not quite there yet.
Donate, help, right? And I think
Stay informed.
You said they're engaged. Well, the federal government's always been engaged. But now they're engaged in the right stinking direction. Right? It's because we might have had, they were engaged fighting us. Now they've decided not to fight us. No. The pendulum has swung completely the other direction to where they're supporting us. Now is the time. Now is the time to strike this stuff, these anti-gun legislation and anti-gun laws and whatever. We need to strike it all dead. And the only way we can do that is to get in the fight. Well, Chuck, is there anything we haven't talked about? Thank you for letting me opine here and be hyperbolic a little bit. I
mentioned Rhodey. Rhodey will
That's
be
the
going
ammo case, right?
That's the ammo background check case. Yeah, we won twice, and now the en banc court's going to take a look at it. But if the U.S. government will get involved there, and if we don't win in front of that en banc panel, which has been notoriously against us, but the composition of that panel may have changed, then we'll go to the Supreme Court on that one, because that's the one that makes it possible to require background checks on non-firearms. So you're going to have a background check on barrels now in California. This is the kind of thing we got to stop, because you'll have to have a background check on a sling next thing you know what I mean? So we're still fighting there. We did knock out that junior sports magazine, the ban on marketing anything that appeals to minors. Now that's huge, because that was designed to wipe out junior shooting sports and end the shooting, end the cultural evolution of shooting sports from generation to generation. Now that's back. We've got all that. That's a complete win. So we've won that one, and we're going on now. While we're challenging sensitive places cases, we have those. CRPA has a dozen cases going on. So go to their website. You can see all the things we're doing, and join. Or if you're afraid of getting on a list, by the way, sign up your dog, or just send a donation. It's either way. And by the way,
your dog is going to be pissed when it starts getting junk mail. That's all I got to say.
We got a lot of Fidos. We got a lot of Fido Bow Wow members. And it's fine with me.
Whatever works.
The magazine goes to their house. The emails go. So, but we never disclose those names. By the way, none of the Pro 2A groups ever disclose the names of their members. But I know some people are nervous about it. So, but anyway, you got to be in the fight. And if you make a donation, if you contribute either your time or your money, and by the way, the CRPA has chapters all over the state. You can get involved locally that way, and they're making a huge difference. The NRA is trying to come back into gear in California. We'll see if they can pull it off. But if you're involved in either way, it's time with time or money, then you're part of history, because this is a historic time for Second Amendment jurisprudence. It's going to be something that our children will have to live with, good, bad, or ugly. And I think it's going to be good.
Go to crpa.org. Please join, donate. Go to the Second Amendment Law Center, which is 2A, what is it?
2ALC.org.
2ALC.org.
Numeral 2ALC.org.
Yeah, I was going to screw that up. Yeah, it's the number 2, not spelled out. 2ALC.org. Chuck, thank you. Have a wonderful week, brother.
You too. Thank you.